In this module, we're looking at the rules of natural justice, or procedural fairness. As usual in administrative law, where we could go for one simple term, we go for two different ones that mean the same thing. And there's a lot of toing and froing between those, but the first thing you have to remember is that when we talk about natural justice and procedural fairness, we tend to use those terms interchangeably. The ADJR Act does refer to natural justice, but judges have expressed an opinion that they would prefer to use the word procedural fairness, just to keep things confusing. And others have mentioned the duty to act judicially or the duty to act fairly as other alternatives. So where does all this come from? What do all these things mean, and how is it different from what we looked at last module in terms of jurisdictional error? Okay, well, what we're talking about, and I'll try and use the phrase natural justice throughout here just for simplicity, but what natural justice comes down to is there assumptions when you give someone a set of powers to exercise that they will do it fairly? So this gets back to our assumptions about good government and our assumptions that if you give someone something to do, they'll do it fairly, correctly, and in the right way. Crucially, the requirement to act with natural justice is rebuttable. If there's a piece of legislation that says, and the rules of natural justice do not apply here, then they don't. Although courts can be very creative in working their way around that. And it's something that I would think would be very difficult politically to argue in any particular case, that you would say, here's a power I'm giving to a functionary of the government, and we don't expect them to act in a fair way. People would probably be a little annoyed if they heard about that, or if they were interested enough to actually find out that that had happened. But maybe not. Maybe they wouldn't notice, if I'm being cynical about it. So the concept has its origin in a case called Spackman's case. It's a Victorian case where basically for the first time we were deciding, well, we can set up administrative bodies. We can give them powers and we can give them guidelines as how to exercise those powers. But what if we don't give them guidelines? What if we just say, you're the dog catcher, go catch dogs for the purpose of keeping stray dogs off the street? Is there a presumption in there that there's a duty to act in a way that's fair and just? And in Spackman's case, the English court said yes. In all things being equal, we don't have to spell out every single time we create a power. We don't have to say, and by the way, you've got to exercise it properly. You've got to do it fairly. Whatever, these things are assumed as part of the system. And this is where some of the confusion, I think, came from when they talk about the duty to act judicially. And it's an unnecessary set of confusions, really. But what we effectively had was a system of a judicial system that had developed through custom and use, these rules about fairness and giving people a hearing, not being biased, all these things we're going to come to in a moment. And it had just been things that courts had evolved over the years. And what they were saying is, well, if we do it, there's no reason why these sort of functionaries and flunkies shouldn't do it as well. So that's when they talk about the duty to act judicially. If that's going to start confusing you about, well, this is administrative power, just don't worry about it. What they're just saying is, we think people should be forced to act the way we are, the way we do. At least unless the government has a very good reason why they shouldn't, and in which case, some areas maybe where there's emergencies, you might say, you don't have time to require everyone to act in a way that gives everyone a right to a fair hearing. The firefighter who comes in and knocks in the door with an axe to save you from the fire. You don't want to be in a position where that firefighter has to knock on the door and say, by the way, look, I'm going to knock your door in with an axe because I can't get in to save you, but I need to give you the right to be heard to express your opinion as to whether you think I should knock your door in or not. Obviously, there are emergency situations and some situations where the duty to give everyone a fair hearing and have everyone have a say is going to create a problem. There are not that many of them, of course, but there are some. Now, as I mentioned, they can be excluded, and they can be excluded by legislation, and the Jarrett case is a more recent case that talks about that. Have a look at that in your notes. But of course, this has all been enshrined in Section 5, Subsection 1, Subsection A of the ADJR Act, so you need to have a look at that. And there are really traditionally two components to what natural justice means, and a third that's a kind of a doesn't fit in anywhere category, and we'll come to that in a moment. So the two ones that are traditional are the right to a fair hearing and the rule against bias. The third one is the no evidence rule, and that's one that some people fit in with jurisdictional error, some people fit in with unreasonableness, some people fit it in with natural justice. I personally fit it in with natural justice, but at the end of the day, it doesn't really matter, because these are all grounds under the ADJR Act, so it really doesn't matter which conceptual pigeonhole you put it in. But we'll talk about the no evidence rule in a moment anyway, just to fill them in. So what it is, and again, I don't want to confuse you with the duty to act judicially, but it's just saying, let's look at the guidelines and the practices we've evolved in the courtroom, particularly in criminal law, and let's use those as a blueprint for the way in which we expect our government officers to act. So we expect anytime someone's rights are going to be affected, that they have a right to fair hearing, that they have a right to come along and express their opinion. We also expect that the decision maker to be impartial. And finally, we expect the decision maker to make their decision on the basis of good evidence. And this is different to what we looked at last week with relevant and irrelevant considerations. It's similar, but it's actually quite different. Because when we're talking about evidence, we're not talking about whether it's relevant or irrelevant. What we're saying is there has to be a process by which you weigh information and you determine facts. And you need to be able to say with some certainty that you have procedures around that. You're not just making stuff up as you go along. So have a look at the notes, have a look at that. Fair hearing is fairly straightforward. Of course, there are different situations in terms of whether something's a preliminary or a final decision, in which case, often you don't give someone a right to be heard on a preliminary decision because you're going to make a final decision later. You notify them, there's a preliminary decision. If you want to object to that, you have 14 days to lodge a complaint or something like that. The difference of whether it's a public or private proceeding can be different in different circumstances. And certainly there's a feeling in the case law that if you are going to humiliate or embarrass someone in public, you've better make sure you've given them a right to respond to those accusations rather than just publicly pillory them. Whether the legislation has its own formalities required, urgency is another issue, and whether your rights have specifically been affected or you're just a member of a broad class. Now, in most situations, we generally do allow people who are members of a broad class also to be heard in a situation. So planning permits, the sign goes up and says, anyone in the public who has an objection can lodge an objection to a liquor license being given to this venue. And, I think mostly mad people put objections into those things. But there might be legitimate things that people come along and say, we don't believe a liquor license is appropriate at this venue for whatever reason. Not sure what reasons people give. And anyone who works in local government, make some inquiries and let me know what sort of things people object to there. I know in my local area, the Dandenong Hills, there was a lot of objection about a McDonald's being given a planning permission to build and operate a McDonald's family restaurant, to use the formal term. And part of that was there was not necessarily a direct impact on individuals, but individuals said, we don't want to have a big corporate fast food chain in our beautiful and unspoiled location. And there was certainly a great deal of sort of middle class snobbery involved in that, and certainly a sense in which people felt entitled to not have a business that they didn't like. And I'm not making any judgments here about McDonald's as a business, that they've done some terrible things in the past, but whether or not members of the community then necessarily have a right to that business opening in an area under planning laws. And in the final decision, the I think it went to VCAT, and VCAT said, no, you can't object to it. You've got no grounds to object to it. And that's been a very sore point in the local community, because they believe that this is some kind of external pernicious influence that's coming in and corrupting children. The fact that it's opened opposite a school is probably part of it as well. And, you know, people are afraid that kids are, you know, spending their lunch money at McDonald's rather than on the beautiful, healthy gourmet food that the tuck shop no doubt provides. But getting back to the point, part of the aspect of a fair hearing is, well, who should have a right to a fair hearing? Who is going to be affected by a decision, and how broadly do you allow people to make submissions, and how much time do they take up? Can they just write a letter? That doesn't take much. They can write a letter, you can read the letter, and you can consider it. Do you have public hearings where everyone can come along and bang their sticks and say, we demand this, we demand that? So all those things go into a decision of what's a fair hearing. And it's one of those things that's also evolving now in terms of digital media, because you can have a fair hearing in a way that's very, very simple and very quick using internet technologies. Whereas in the past, you know, notifying people, putting up signs, getting people onto public hearings, getting people to speak, getting people to shut up when they start speaking, all those sorts of things made this very complicated. And there's a bit of literature around on digital government and joined up government, and how we're not really taking advantage of some of those mechanisms we have for getting people involved in those governance decisions. Anyway, that's the fair hearing. That's the first of the three. The second is the rule against bias. And this is changing, because when I studied the rule against bias, we were basically told just because you were a biased person didn't mean that you were actually a biased decision maker. And there's all sorts of cases where people were horrible racists and awful people, and they said, well, that doesn't actually mean they're a biased decision maker. It just means that they're biased as people, but that doesn't mean they're necessarily going to make a decision that's an awful racist decision. And that was often a very semantic decision, and it was often, I think, part of the problem was the effect of proving this thing. And, you know, just because someone has a history of always knocking back planning permission for people from one ethnic community, does that mean they're biased, or doesn't it? Anyway, so the old sort of hardcore version of the rule against bias was always you had to have a personal or financial interest to be biased. So it had to literally be a conflict of interest, where you were biased in making a decision because you were deciding between these two businesses which one would operate, and you have, you know, shares in that business or something along those lines. Now that rule has been broadened, and I'd refer you to the GIA case, JIA case, where the High Court has recently kind of expanded that, and they talk about the idea of prejudgment. So you don't actually have to have a personal interest in a case, but you need some sort of proof that that person has made the decision before they've listened to the hearing. So it's not enough to say this person has a propensity, or they're someone who necessarily, you know, it's easier to make this argument to this person, and this person is notoriously difficult to argue this before. That's not enough. You have to actually show that that person is not listening to any of the process. They're not actually giving you a fair hearing. They've made up their mind before they go in. But there's an interesting obiter dicta in that case from Justice Hayne, who does often surprise me with some of the things that he says, where he takes a much broader view, and he basically says, you know, biased people are biased, and that's a breach of process, and that's a major problem. And as far as I can see, that's still only obiter in that case, but it's certainly a long way away from the days when I studied, where you could actually, you know, come into your office with the white hood and robes on, and claim you weren't a biased decision maker because, you know, you didn't have a financial interest in the outcome, while you're sitting light to the cross you're burning in your front yard. We certainly, and of course there are all sorts of other forms of bias as well. We don't just talk about racial bias, but I think the courts are now much more confident in interceding and saying whether it's clear that someone is a biased decision maker, then there's something wrong with the process, regardless of their own interests. All right, and the third element of this that we talk about is the no evidence rule. As I said, this is one where someone puts it somewhere, someone puts it somewhere else, they're not sure where to put it, and at the end of the day, the rest of us just say, it's in the ADJR, it doesn't matter where it goes. No, it doesn't matter where it goes. I think it fits quite neatly under natural justice, because I think that's a situation where we're looking at the kinds of court-like things and court-like behaviour we're expecting from decision makers, and we definitely, under Section 5, subsection 1, subsection H, expect there to be a process involved in the gathering of evidence. It doesn't have the same standards as court, and for instance, something like hearsay. Hearsay is not admissible in almost every circumstance, apart from some strange ones, in court. And you're going to study evidence sooner or later, and you'll find out all about that. And that's, the foundation of the rule against hearsay is really the idea of the best evidence. You always produce the best evidence that you've got. And if someone says, Doug said this, then get Doug along to say that. Don't get Bob along to say that Bob heard Doug say that. And that's the foundation of the hearsay rule, all right? You'll study that later. In terms of administrative decision making, of course, they're not bound by that. They can listen to Doug and they can say, they can listen to Bob and say, yeah, Doug said that. Okay, I'll take that into consideration. But what we expect is we don't expect strict rules of evidence in the same way that the court has, but we expect there to be some kind of weighing up process. There needs to be a process by which the decision maker says, well, of course, we didn't have Doug tell us that. Now, we're going to believe Bob in this circumstance, and we're going to believe that he was right in telling us that Doug said that. But we're not going to give it as much weight as if Doug had actually come along and said that directly to us. So the same sort of principles apply to the other rules of evidence, which you'll have the pleasure of studying at length, and learning about wives being dissolved in acid baths and all sorts of other ghoulish things that happen in the evidence course. But that's just sort of one example. But the one thing that is clear about the no evidence rule is it's not enough just to say they're wrong. So we're not actually going far enough to say that the courts are rejudging the facts. And just because someone made a decision that something was true that wasn't true, that doesn't give the courts enough of an in to go in and challenge the decision just because they were actually wrong. However, if you can prove that their process was bad and that they shouldn't have been wrong, they should have found the right answer, okay, it's a small distinction, but hey, this is law, this is all about those small distinctions, then that's enough. So if they're fair, above board, objective, they make a decision and guess what, they're wrong, and you can prove they're wrong, that is not enough for judicial review. But that seldom happens. And usually when something factual is wrong, it's because there's something wrong with the process. It's because there's something wrong with there hasn't been a hearing. There hasn't been the decision maker's been biased. There's no proper evidence. So in those circumstances, it's generally easy. It's not so hard to prove that, okay, it's neither here nor there that the fact is wrong, but the process by which that fact was determined itself is a problem. So that's natural justice. Remember those three principles: fair hearing, no bias, proper evidence. Next week we'll move on to the third and final of these sections, where we look at principles, and we're going to look at a grab bag of bad behaviour. We're going to look at fraud, we're going to look at unreasonableness, and we're going to look at lots of similar things. So look forward to talking to you about that next time.